a very good afternoon, and good afternoon to all the people who are watching us today. So the good news today from my side is that we are going to talk about a really important, really talked about and beautiful topic, I would say, fraudulent entry and adjustment of status in family-based immigration matters. And of course, we have you.
Anjali, let me tell you, let's cheer up a bit. Let some more people join, and it's wonderful being here. Now, just basically, basic run around as to what's going to happen today. And if people are not here, even if they're seasoned lawyers, and if you're a paralegal watching, you're really going to learn a lot. And this is something that not many people have done in the past, because this is where you really hone your litigation skills. This is where you actually become an immigration litigator. That's what we're going to talk about. And there'll be some very complicated issues that we'll be discussing today. And if you're a paralegal or if you're a new attorney, you can also ask your boss to join. Than anything else. So we are going to talk today all the way up to how can you take these cases, right up to a federal level. So Anjali, that's what we're going to talk about. Are you there? Anjali, are you there? Yes, so folks are. Yes, so I think, sorry, we'll have some computer issues, so don't leave because I think it's, the network, so we'll have to bear with that. So great. So let's get to this and let's, give everyone a brief background, what we are going to discuss about and how this can really help lawyers. So firstly, thank you to My Legal Software for hosting these sessions, and big fan of My Legal Software as a founder, plus also as a user more than anything else. The biggest thing is that about the case at hand, it's about fraudulent entry. And the common misconception is that if a client has a fraudulent entry, he cannot get a green card in America. A lot of lawyers give up these cases because they know this is hard. The reason it is important is because there are some clients, they don't want to go for the 601 waiver. They don't want to leave the 601A waiver, to be more precise with. And that's known as the unlawful presence waiver under 212A9B of the INA. They just don't want to leave the country. And also they're coming to your office and they're telling you that whatever it takes, any amount of time it takes, I want to try to get my green card in the United States of America. I'm sure this is not the first time you all are hearing it. A lot of you might have heard this on many occasions. So that's what we are going to discuss today. So Anjali, tell me if you have any questions, or how are you doing with My Legal Software, and what else we can add to the session later. Yes.
So before we start with all the information, I'd just like to give a brief introduction for myself to all our viewers. First of all, thank you everyone for joining in. And good afternoon, good morning to everyone from wherever you are. I'm Anjali and I'm your moderator for today. I'm also heading the sales and marketing division for My Legal Software. So My Legal Software is basically a legal case management software that is created for the lawyers by the lawyers. And today is September 1st, and we're going to talk about a very important topic, and a lot of people have talked about it, but nobody talks about it publicly. So the topic is fraudulent entry and adjustment of status in the family-based immigration matters. Talking about My Legal Software, so My Legal Software it's a software for the law firms, for the lawyers who belong to any practice area. We help them by organizing their projects, their cases, their clients, their document management, their billing, even team collaboration for that matter. And so your firm itself, I think they handle close to 17,000 cases with the software. So I think you, as a user, can tell me what are the best things that you like about the software.
All right. So before we get to the topic, I'll just give a brief introduction. What I like the hourly billing feature. I like one feature very much is that when my associate leaves, and things don't fall through the cracks because you have a fantastic assignment and reassignment feature. Also, I save money in credit card fees because the billing goes to the client here, and that is integrated with it. I like the accounting feature because it complements me. I can get my accounting done there. And plus, besides that, the deadline features are amazing. You have a great chat feature in it. You have a texting feature. And the best thing is that I've tried other softwares in the past. You have amazing reports. And also, like, you can look at every paralegal or lawyer's kind of task, what they've done. And the deadline management is just out of this world. And also, when I use the software, you get to the retainer step by step. So no one can skip the process. And one has to actually kind of take a demo to understand what I'm saying. And it's a free demo, which is, I think, a no cost or obligation. And above all, you'll also get legal help, from lawyers, seasoned attorneys if you're stuck with a legal problem. And if it is in any other area of the law, we can do the research and get back to you. And it's not only good for immigration lawyers, it can be good for any practice of any kind. And for example, we do bankruptcies. So I was even able to use that bankruptcy software and integrate it with this. So that's what I like about this. So integrations are possible. And even if I had old documents, I can upload them well. The templates are amazing. So I use the templates all the time so I can finish up my work very quickly. And a lot of my workers are remote and they work on the software, and I'm also able to save money. So that's what I like about it.
Thank you, sir. Thank you for your kind words.
Okay, because I like to hit the nail on the head and get started with the topic right away. That's the whole idea for this. Fraudulent entry. So first talk about what is fraudulent entry. So I'm going to give simple examples, especially to new lawyers and lawyers kind of basically want to learn and who want to kind of understand immigration. Take a simple example. And this is one mistake which is done by a lot of lawyers. Your client comes to America from an airport. Take an example. In New York. And he doesn't have a copy of the passport. And he came into the country. And once he came into the country, you are presuming that his entry is fraudulent. Ask the client whether he even seen the passport or no. He says, I don't remember. That's a good answer. He does not have the passport and he does not know which passport was used during the entry. That's a very important thing. That is a very important thing for us to know. And once that happens, you have at least established that he entered. What is the requirement for an entry? That is super important for us to understand. There are two types of entries in immigration law. One is entry without inspection, wherein an immigration officer did not see you, or you are not inspected through a machine or through an electronic device which has been authorized by the US government as an entry modem. So that is an EWI, immigration without inspection. Second is immigration with inspection. The common misconception is that you have to have a passport to be inspected. You are 100% wrong. Yes, I've done a case. We've been able to win that too. So as I said, this is yes, we have. We've done that too. But you have to be an aggressive lawyer to do that. And you have to stand your ground. And your client has to really speak the truth. And if he does, then you have the right to fight your case. So now, immigration with inspection means, first thing is that, yes, the common thing is that people think you need a visa. You don't need a visa. Somehow you entered the US and you are inspected by the officer. Take an example, you're coming from Mexico. And the officer meets you at the border. That's why that's known as an arriving alien there. I don't want to confuse you, but you met the officer at the border. That's why they are calling it an arriving alien. Means you are inspected. Fantastic. But when you're coming through the airport, the officer seen you. And what happens in a lot of these cases, people who accompany them, they come to America, after they enter, they take the documents back and they disappear. And your client is in a predicament that he doesn't have the proof of entry. And now, It's been years. He's married to this American citizen, and the American citizen spouse, let's call it, or call her as Miss Jane. Jane is very scared to send her husband back for a 601A provisional waiver. And, John doesn't want to take the risk of going back. Understandable, everyone is different. You convince him a lot. First, talk to the client. Ask him whether he's comfortable or no. Rule number one. But if he says that under no circumstances he wants to go back, then after that, if you are a lawyer like who really wants to hone his litigation skills, take this case up and we'll back you up. And I'm going to tell you about this, how we took it to federal court and how did we fight it. Even, experienced lawyers are going to love the strategy. All right. So here goes it. So the thing is that in my case, what happened here is that now John doesn't want to go back, correct? And he was inspected. So I had a case similar to this, wherein one of my clients entered on someone else's passport. All right. And then after that, what we did in this case is we applied for adjustment of status. All right. Went before the officer, and the leading case on the point for scholars and people who love these sessions is the matter of Arguelin. And the second case on the point is the matter of Quill and Tan. So those two cases are very important for lawyers to know. So the biggest and the most important thing in these cases is when you go before the USCIS officer, he's going to have the long interview sheet with the client. Don't be afraid, don't be disheartened. Just make sure that your client knows every step of how he entered. Every step. He can even ask you, do you remember the color of the clothes of the person who's seen you? He is trying to see whether the person was actually inspected. Sad, but it's a reality. They deep dive into it. Now, when they deep dive into it, there are two types of supervisors. Some of them are good, very few of them. But rest of them are like, nah, I don't want to give this guy a green card. Why? You did not prove it. Thank you, folks. When it comes to denying cases, they use this as a sword. Oh, you did a fraud. But when it comes to granting cases, no. Don't tell me I don't believe you. So now, our client appeared before the USCIS for a 485 interview. So the officer had a long interview session. Great, well and fantastic and dandy. They denied the case. Well, we understand that you said that you came in on someone else's passport. You did not provide a copy of the passport of the I-94. Hey, officer, we told you that. We don't have it, but the case law requires you to still listen to my testimony. And we also basically brought to the officer's attention the matter of Mugharabi, that sometimes. So we also mentioned to the officer, he's under oath. And when a person generally lies under oath, you all believe that and give them a fraud waiver. Why not? That does not apply in this case. So we came up with this theory of the double-edged sword. So when it benefits the government, then you're going to ask the person to apply for a fraud waiver. When it's benefiting our client, you're going to say it doesn't apply. I said, law cannot work like this. You need to have a policy in that regard. Case was denied by the immigration officer. We filed a motion to reopen. Motion to reopen was denied. But in the meanwhile, I was also working on something else here. I also had filed a 601A waiver. Yes. 601 was so that if she goes back to the country, she should be able to come back. And she has to apply for the fraud waiver. I thought about that already, and I'll come to that and I'll tell you what I did for that. So now, senior lawyers might be thinking, I know that. That's something that I can see what's going on here in people's minds. All right. So this is the twist of the case. And I've spoken to many lawyers at AILA. They were very impressed with what I had done, my firm had done, not me. Credit to my entire team. I don't like to take credit. It's my team that owes me everything, not me. So I'm just basically the guy who thinks about it and I tell them this is what we need to do. So now 601 is approved. 601A is approved. I'm so sorry. 601A is approved. The provisional waiver is approved. I-130 is approved. 485 has been denied. And 601 is not approved. All right, because if it would have been approved, they would have given it because they are not believing the entry. So now I filed a motion to reopen, and the motion was denied by the government. All right, no problem. So what I did is that I filed a 601 before the USCIS, asking them to adjudicate it because the 601A has been approved. And they were not very happy about it because they said that's not possible because the person has to be outside the United States. I said, I disagree with that after looking at the plain language of the law. And I said that under 601A requirements, when a person is in America, when I'm submitting the I-130 and the 485, I can also submit the 601. So the provisional waiver also gave us the same, the requirements should be the same. You cannot have two different requirements for people. And my client is admitting that she entered on a fraudulent passport. So the consular officer does not have to make a decision when the client is openly admitting. We filed the papers with the USCIS waiver branch, they denied it. All right. They said that the consulate has the right. I said, you're saying that one has to go there and the consulate has to decide? I said, the consulate has to decide nothing when my client is already in agreement. Well, the argument was not gave them food for thought. They said, oh my God, haven't seen this before. Filed an appeal that got denied. Now I take the case to federal court. And I know that when I'm going to take it to federal court, most lawyers might be thinking now this is going to go to the IJ. No, I did not do that. We filed it as a class action. Because there are many other people who are in similar situations. And when we filed it as a class action, I knew that the case will not go to the IJ. Because the class action cannot be adjudicated before the immigration court. So the matter stayed there. The battle went on for a very, very long time. And finally, what happened is that during that time, they were called again for the 485. Applied again. 601 was applied again. And they admitted the entry of my client. They said, now we believe you. And we recognize that exactly you proved the case. First time they denied it. I said, I'm not withdrawing the action. We are going to continue this. Then again, after that, we went before the USCIS officer. They finally applied Argulin. And they applied Quilintan, and the 601 waiver was approved in the US. Client did not have to leave the United States and she got a green card. So folks, don't look behind. Go to federal court if necessary. Fight these cases. And there are two things that can happen when you go to federal court. If you have a lot of people, make it a class action. But if you don't have a lot of people, still take it to federal district court. And the matter will be going to the immigration court. We have done that too. So now, people are going to say that there are two types of judges. One are those who are very conservative. And second are those judges who basically believe you. But to be a conservative lawyer, what I generally do in these cases, in some of these cases, I also make sure that my client is eligible for cancellation of removal. Cancellation of removal falls under Section 240 of the INA, wherein exactly you have to show that will be extreme, exceptional, and unusual hardship to your spouse or basically to your parents or children. All right, well and good and dandy. So what happens is then when I'm before the IJ, then after that, the government and I decide as to which would be a good strategy to go. Even the judges, most of them are wonderful. They say this is the way to go. And through that, you can qualify your plan for a green card. So when you are in immigration court, and if you're a new lawyer or if you're someone who wants to learn immigration practice in detail, I like the system very much because they have templates and everything. I use a lot of templates from my legal software here. use all the features that it comes in very handy for me to look at my old cases and just pick one up and go from there. And folks, the mentorship program is amazing. They have researchers and everything. That's something that I take advantage of all the time. And it's a very reasonably priced software. It's cheaper than the best softwares I might have seen. And plus the features are beyond imaginable. You just have to get a demo from them. But take your time, look at it only when you're comfortable. Now, after that, I got this template. I made sure that I have everything. And what I did when I'm before the IJ and when I'm in the cancellation case, now in cancellation, there's good news for you. When you're in cancellation, the good news is entry doesn't matter, except for the fact that if you entered on a C1, or even if you entered on a fraudulent passport, except for a US citizen passport, to be very sure about the way I talk, I like to be perfect. The good news for you is you don't have to apply for a fraud waiver. Even if you're admitting before the IJ that you committed a fraud. Because you're adjusting under Section 240 of the INA, not under 245. That's why I said this session will be very good to a lot of lawyers, and I've done this before. And when you make that kind of argument, some of these trial attorneys are very good. They are going to grill your client. How did I do my trial in this case? Worth listening. So when I had my case in which they were unable to they were kind of basically not ready to listen that my client actually entered on someone else's part, or they didn't want to believe them, or they said client doesn't seem credible. So what I did, I went to the extent of getting polygraph tests. So polygraph test can be a game changer. And I got affidavits. And I also cited Mogarabi. I said, my client is under oath. That means a lot in this nation. And judge said, fantastic job. And the judge believed my client. And the client qualified. So folks, whenever you get this fraudulent entry case, the government is going to say some important things in your decision when you get a denial. So we're going to talk about the denials in the next few minutes. But if there's any question, I'm just going to take a pause for 1 minute. And Anjali, you can ask me any questions that you may have. So we'll go to the second part of this session, which is going to be equally important. Hope everyone is enjoying. If you have friends who want to join in, still it's going to be very good. And we're going to talk about some very important issues, especially how the trial should be conducted and what evidence is needed, what to do when you don't have evidence, how is the government going to come up with their questioning, and how you're going to answer them. That's going to be the next one.
So it's my request to all the attendees that in case if you have any questions, you can let us know in the comments or from wherever you're watching. We'll answer all your questions at the end with Mr. Gehi. Alternatively, you can also email us your questions on legalquestions@mylegalsoftware.com. I'd repeat the email ID. It's legalquestions@mylegalsoftware.com. So I would like to take this opportunity to tell all my audience that people who are watching, we also provide free legal mentorship to the lawyers. In case if you have any questions or if you are stuck in the case anywhere, we would try to provide our legal mentorship from our attorney panel. All you have to do is either call us or you can email us your query on legalquestions@mylegalsoftware.com. And the attendees also have a chance to win the gift hamper. They have to take the picture or the screenshot of this event and they have to post it on their social media handles and tag us.
And they have to be law firms and lawyers. That's what you said. So
yeah, they have to be from law firms and lawyers. Also, sir, we have gotten a lot of requests from our previous lawyers who have attended the webinars that they would want to speak as guest speaker for the next webinars. So we are booked for a couple of webinars, but in case if you're a lawyer, an experienced lawyer who has a good knowledge and experience about the topic, you can email us your resume on legalquestions@mylegalsoftware.com, and you may get a chance to be our guest speaker. And as you become our guest speaker, you also get a chance that we feature you on our website, on our social media handles, and you also get a good kind of credibility when you speak as a guest speaker in our forum.
Right. For lawyers to develop business and show your skills that you're very good in a particular area. It can be not only in immigration, it can be in any area of the law. So, for example, we had some PI lawyers who wanted to come in, but we look at the resume very carefully. We have a team, I believe, in which I think people will look at it. And if you're really good at what you do, you'll get an opportunity to come in and speak here. You've got to be very good at what you do. And there's a screening process. And if you're good, then only I think, we take up, because we get a lot of requests, but we make sure that we need to have the best over here in this particular program. And because we want lawyers to take law to the next level. We want lawyers who came out from law school, who started the practice. We don't want them to be scared. And besides immigration, we are also going to talk about other areas, including federal practice. Not only in immigration, I'm going to talk about labor law very soon, FLSAs and everything, but eventually, as the momentum builds up. So now, if there's any question, please do start asking questions, and because, that's the best way to make it special. Now, first question here, did you handle any case that went to federal court? Yes. I've handled many cases, immigration court. And some of the cases we've handled are mandamus actions, federal district court actions relating to citizenship, fraudulent entries in the United States, and above all, Second Circuit cases also have been handled by the firm. So we have handled federal cases, and for people who want to learn federal practice, I think to be kind of, taking things to the next level. So now comes the important part of how do these cases work. And I spoke about my experience wherein we went as class action attorneys in this case, and we filed it as a class action. But when you're not going to file it as a class action in federal court, the case will be referred by the government to the immigration judge. And when it goes before the immigration judge, generally judges are even surprised that cases like this are coming to the court. And the government's argument in these cases generally is that he doesn't have proof of entry. He does not have a passport. He does not have an I-94. All right. Then it's important for you to know the case laws from the back of your head. Don't be scared. Even at the first master calendar hearing, even if you're a new lawyer, we have your back. We'll help you. Even if you practice immigration before, no, it doesn't matter. A lot of people were coming to us, they want to start their asylum practice. Even if you're a PI lawyer, doesn't matter. If you're a matrimonial lawyer, doesn't matter. We'll help you from the back if you want to take up immigration, or if you are scared of taking things to federal court, and that happens. Everyone has something, and you're good at something else, but you want to become what you want to be. The government is saying over your example that, he doesn't have a copy of the passport. The next is that he's not a credible witness. I don't think so. I can believe this person. And third, they're going to say that they don't have an I-94. All right. Now, what happens to you while you're an attorney in the court? The first feeling is that you're nervous. Don't be nervous. Why? Because the law is on your side. From the BIA, the leading decision on the point, the matter of argument, makes it very clear that it is the person who's inspected, it's not the passport. It's the human being that is inspected. And I also argued the case in the other way. I said, just imagine a situation when the person is living in another country, he's in Iceland, and he never came to America, but his passport went through immigration and came here. I said, Judge, is it possible now to get the person a green card when he's sitting in Iceland? Therefore, I said, when the decision was made, the judges were very thoughtful They said it cannot be the passport that has to be inspected. It is the human being that has to be inspected. So explain your case properly. Prepare your client with credibility issues. Make sure he knows what is the definition of the word credibility. Spend the time and charge your fee. And these cases can go up to $25,000 or $35,000, folks. You just need 10 cases like this. And we will teach you. If you're interested in fighting, we'll teach you. That's what we are here for. Build your practice. Because these things here take time, it takes years, and you need to let your client know. But there are clients who want to pay that kind of money because they don't want to leave the United States. Then when it comes to the trial, especially in these cases, wherein the person has been here for more than 10 years, I always make sure that you demonstrate your hardship very well, because you're taking 2 bites of the apple here. The first bite of the apple is adjustment of status. And don't budge. Don't tell the judge your client is adjustable. And what is the judge going to ask you at the master calendar hearing? Counselor, let me know. Your client was referred in removal proceedings because I believe the federal court said because of exhaustion of remedies, you have to come to us. Yes, we are here. You are over there now. You're very happy to be in court and you're unhappy to be in court because you know that you're going to get a decision. So you're going to get the decision over here, and you got the decision that you're before the immigration judge. You got the decision that you're before the immigration judge now. And the judge wants to know, why should I give you the green card? Judge, 2 reasons. Number 1, do you admit the allegations in the notice to appear? Yes, I do. How do you plead? Okay, basically, are you seeking any release before the court? Adjustment of status under 245A of the INA. Some judges will tell you you're not adjustable. Do not be scared. Do not be scared. Tell them, yes, my client is adjustable. I need time to write a memo. Because some judges and some TAs are new, they do not know the matter of argument very well. And I've seen that happening. And also let them know under Quillintan, my client is adjustable. Then the judge will tell you, okay, I'm going to give it time to submit your memo. So you already got one thing in control over here. Second thing, what you do in this case is submit the 240 application by filing the Form Eoi 42B. Lawyers commit a mistake sometimes. They file Eoi 42A. There's a big difference between Eoi 42A and Eoi 42B. EOIR 42A applies to people who are permanent residents. EOIR 42B applies to people who are non-permanent residents. So know the distinction very well. So now you apply for EOIR 42B, but remember, when you're filing the EOIR 42B, the hardship levels are very high. The law on the point is extreme, exceptional, and unusual hardship. Is it difficult? It's okay. Don't be scared. You're having 2 bites of the apple. You have 2 bites of the apple. And even the government wants to make sure that the case reaches a decision because, even they know that if it goes up, the judge may grant it, before the federal court or something. And it's a waste of money and a lot of resources sometimes. And generally, most government attorneys are good. They'll say, okay, take it under cancellation. We're okay. You need a green card. Doesn't matter whether you got it under cancellation under 240 or whether you got it under 245A of the INA. File your case. Don't forget to cite some interesting cases when you're fighting for cancellation or removal. Cancellation of removal is a different area of law. We are going to talk about it in one of our sessions, and you'll also learn how to do cancellations in these sessions. The leading cases on the point are the matter of Monreal, the matter of Andazola, and the matter of Resinas. Know it from the back of your head like this. Comply with the requirements. Make sure that you have a seasoned lawyer to back you up. When you are putting any package before the immigration court, and they tell me, Mr. Gehi, I have a case, but I didn't do well sometimes. I said, you didn't do well because you did not document it properly. So for that, it's good to take some advice, from mentors or from peers. MILS can always, if you need me, if you sign up with MILS, I'd be happy to come in and help you out. Of course, you have to be a member of MILS and, whatever the requirements, I don't want to get into that. If they are there, then I'm there for you. That's how the rules are based upon my contract. So then make sure documentation is perfect. And I can assure you, doesn't matter which part of the country you are in. If you document a case well, and if you can show the hardship properly, there's a very, very good chance that you will win those cases. We've done it on many occasions. We get cases from other lawyers. A retired New York Supreme Court judge, he refers cases to us. A lot of lawyers, they refer cases to my firm, especially when it gets complicated. And we work with them. So end of the day, bottom line is that if your trial skills are good, if you know how to kind of conduct a good immigration trial, you'll definitely do well on the case. They take some classes in trial skills because I've done trials in landlord-tenant courts. I've done trials in immigration. I've done trials literally on many different occasions. So trial is an art, and learn to object in immigration court. And for that, you have to know when to object, how to object, and when the door is opened by the government, whether your client can talk further on an issue, and you'll have to just say that I basically request that this be struck from the record. Learn those terms, and other than that, learn to suppress evidence sometimes. And I see that in immigration, not a lot of lawyers file a motion to suppress. And it doesn't matter whether it gets denied or doesn't. Room for appeal, and you have room to take it to the federal court. So those are things which I want lawyers to learn. That's what I'm expecting people to do well and move on. So I think, Anjali, you have quite a few questions for me here. Let me take another question here. Does USCIS generally grant cases to people who enter on fraudulent passports? USCIS does. Depends. I've had some success, but definitely when you take it to federal court, when you go before the IJ, you're going to see a lot more kind of, grants over there because you get a chance for a full trial. But I've seen this, yes, happening, yes. And yes, we've been successful in many cases, for sure, yes.
So another question is that what to do if I'm inspected by an officer, but I do not have a proof of entry?
Okay. First thing which I tell people is that even if you have a copy of an airline ticket, I've used that too. So try to think what you have with you. Even an airline ticket can be something that you got, and that can be helpful. Or if you entered with a relative or a friend, put in that date, let that person come to court. Excellent. He entered with me, but I didn't know that. But the relative has to be something you have to be very careful about. The relative should not be the smuggler of the person. Look at this, how tricky the law can be, because that person can be charged of smuggling. So you have to be a good lawyer. You have to look at everything under a microscope before you present testimony in court. My background was that I used to work for a retired administrative law judge, wherein exactly I learned litigation very well. Not only immigration litigation, general practice litigation. And being a clerk of a retired judge was a great experience for me. And I had to write memos, I had to write briefs and everything. So I was trained to look at everything from every different corner. Great experience. So if you are just, a good immigration lawyer, but if you haven't done litigation, make sure you pick up a book of litigation or feel free to call us. We are here to help you. We want to make sure that the case law changes in the country and immigrants have better rights. And on a different note for senior lawyers who might be watching, and when it's a fraudulent entry, you can also bring this question up that why is the burden of proof so high in my client's case when he's admitting to a fraudulent entry? And when a person comes in on a regular visa, he gets questioned. And if he even utters the word that he committed a fraud, within a minute, you gave him a fraud waiver without any questions asked. You have the right to bring up those questions. Because the current policy cannot be used as a double-edged sword. It cannot be a policy wherein when it benefits the officer and if it harms the client, the testimony should not be considered. But when it benefits in the denial of the case, it should be considered in that favorable light. There needs to be a proper policy from immigration on this issue. And I don't see a proper policy still there. And one other mistake which some lawyers have done in the past, as I said, these are fantastic educational seminars, for people to learn. You apply for a provisional waiver. The provisional waiver is approved and your client went abroad. Now, when he went before the consulate, he told the consulate that I came on someone else's passport. Oh my God. Now your client is furious because you did not ask him the question before. Ask him that question. Because now he has to apply for a waiver over there and he's going to be held there for 1 year, 2 years. And if it's denied, he's going to be held in his home country and you can rest your license. Be very careful. And in one of the cases, which I know wherein an attorney consulted me, I got a question actually from Anjali on this one when someone contacted MILS. The issue was that my client is saying that he entered on someone else's passport and everything. Just make sure that you don't send him back. Fight the long way. Because if the consulate finds that out, he's stuck over there. That's a fraud over a fraud. Be very careful, folks. And then one of the cases wherein a question came through MILS, everybody, folks, spread the message of My Legal Software. This is a unique opportunity for people to learn and come and speak on this platform and take law to the next level. And I'm also expecting a lot of paralegals to join in and learn from us, lawyers to learn who really want to become lawyers. I'm a big fan of paralegals becoming lawyers, and taking things to the next level. But don't forget to subscribe to My Legal Software, and we are here to watch you. And the only way you can help us, if you're a fan of us, promote us. That's all you can do for us. Because as you see that you're really getting the material you want. So any move that you're taking, be careful. Now, in one of the cases that question came into My Legal Software was that this client came in on someone else's passport and the lawyer asked him to apply for a 601A. Big mistake. And I'm glad the question came. We found that the person was fingerprinted. Wow, you got the proof of entry right there at the airport. Use that, apply for the waiver, and let the government know, here's the proof of entry. You fingerprinted him. You should be eligible for a green card. Apply for the waiver. Folks, do your homework properly. Hope a lot of people learned a lot today. And I think it's been a very interesting session. Next one is going to be a very good session. Should I announce it now? Or Anjali, you want to take questions or what do you want to do?
So let's take a couple of questions and then we'll talk about the next seminar during the end of the session. I hope all of the attendees and all of the people who are watching us live are actually taking notes of what Mr. Gehi is saying here, because these are practical day-to-day life tips that he uses during his cases. Okay, so next question is that what is the eligibility criteria for the spouse of a US citizen to become a permanent resident of the US?
Okay. So the first thing is that that's a good question. If you're a US citizen, if you're sponsoring someone, and if the person was inspected, then under 245A, even if the person has accrued unlawful presence, they can adjust. They came in on a visit visa. But if they came in on a C1D, there's a very narrow window. But on most visas, they are eligible because 245A requires admitted, inspected, or paroled, and here the person was inspected, and the person can adjust provided there are not many adverse factors. So for adverse factors, you have to know the matter of marine, and you have to know the matter of array very well. Good. Good question.
So next question is, do you need a waiver when someone enters on a fraud passport?
Yes, you do. I mentioned that before. The answer is yes.
Okay. So next question is, should you take the case to the federal court?
I tell lawyers, fight. Fight. If your client doesn't want to go back, fight. Fortune favors the brave. The Lord is the strength of the strong. When the great get going, the going gets great. And I'm here to help you. Fight if you have a case. And most things what I've seen is that solo lawyers, they're scared. We will help you. You just take up the case. And by the way, and I'm telling people, the fees in this case are very good. And you just need this little help. How much you're spending on this program? Hardly anything here. Around, how much is it? $65, I believe, for a license in your case. So, just have 4 or 5 licenses are good. And in one case, you're making 4,000. And the other good thing I like about my legal software, this is the unique feature of my legal software, is when I'm using their credit card terminal, which is a third-party integration, the fees are going on. The client has to pay for the fee. So even every month, the good thing is that the fee also, the software comes out to be free. Because your client is absorbing the credit card fee. See how much you're saving. Unlike wherein you have a separate credit card terminal, like, you're using another company and that company is charging you, the bill is going to the client. So the software turns out to be free for me. That's another. And it's applicable in most states. So next question.
Thank you, sir. Sir, next question is, what to do if USCIS denies the case?
Don't worry. Be happy. Remember that song from Billy Joel. So, and there's a saying that, the next part of the song is very interesting from Billy Joel. If you're not happy, take my phone number. Take the phone number for MYLS, call them, and let them know to guide you through the next step. Billy Joel has a song. Don't worry. I think it's Billy Joel. I don't know yet. Be happy. And if you're unhappy, take my phone number. So keep the number. That's a part of the song. So take this number for people who know the song. And then after that, I'll be happy to consult with you. I want to help lawyers to grow. It should be a win-win for everyone. So you fight it out. Don't give up. When the great get going, the going gets great.
Thank you, sir. So much of motivation. So next question is from a lawyer. How should a lawyer fight these cases, especially considering that USCIS denies most of such cases?
So, see, this is one common thing that people give up. File your motion to reopen and file an action in Federal District Court, and we'll give you a hand. And then after that, take your client to immigration court and keep fighting. Don't give up, and you're going to see results. And even before you take up the case, you can consult with us to see a good case, and then we'll see where we take it.
Thank you, sir. So next question is, what happens when a person applies for a provisional waiver? Do they still have to apply for a fraudulent waiver?
No. If there's no fraud, if you entered without inspection, and if there's no fraud at all, you don't need the 601 waiver. You just need the 601A waiver.
Where can I apply for waiver, and when can I apply for the waiver? That is when and where.
Generally, the waiver is applied after your NVC is kind of finished up at that point, somewhere there. Once your NVC begins, that's the time you apply. And, the form itself gives you the instruction of where you're living. Based upon that, you apply to the waiver adjudication branch. And look at the instructions of the 601A carefully. It's written right there.
Just a gentle reminder to the attendees or people who are watching us live, if you have any more questions, You can send us an email on legalquestions@mylegalsoftware.com. You also get a gift chance to win the gift hamper if you put the image of this particular session or put a screenshot of this session on your social media handles, tagging us. So if you're a lawyer, if you're a law firm, you have a chance to win a gift hamper from My Legal Software. So next very important question for you is, how aggressively, Mr. Gehi, do you fight such cases?
Uh, I have fought cases involving terrorism bars, have been successful in them. And there have been occasions wherein my wonderful clients were not terrorists. I proved it to the government, and the government was very nice. We worked together in establishing, and even they got their green cards. So we take up anything, but we make sure that, we talk to the client for a long time. We make sure that exactly, that the facts are good. Please do not make a fool of yourself in federal court. Remember Rule 11 very well. Under Rule 11, if they find that your case is frivolous, you can be sanctioned. And that's a very serious issue. Therefore, when you're going to the federal court for the first time, don't take a chance. Please do not take a chance. Make sure that you have a good lawyer backing you up, for sure. Just more like TLC should be there. Tender love and care is always a must. And folks, I'm a very humble person. I'm also here to learn from you. Treat me as your brother, if you're a professional brother or your professional colleague, and I'm here to help you. I'm always available if that's needed. And as I said, this is the number to call the company, and we are there to basically assist you. And if you're a paralegal, you need to check out the features because I know lawyers are busy, and you need to check out the features of My Legal Software, and you'll see the difference, and you'll be able to explain to your boss, why do you want this? Because it's going to make your life easy as a paralegal too. All the yelling will stop, I can assure you that, because you'll have everything like in one place. Because I know that the biggest problem is that, one paralegal actually spoke to me from here, said, well, I get into trouble all the time when 2 or 3 people leave the company, one person leaves, because your software does not have a good assignment and reassignment system, because you cannot keep track. Here, you need to actually, use this software to believe what it is actually. And the demo's free, and I believe, work with Anjali, that may be good for you.
Yes, sir. So we'll take
Next.
the last question for the day, and then we'll talk about the next coming up webinar. What are the technologies or the books that can help me get through good knowledge of, fraudulent entries and status and everything?
Mentorship is very important in these cases, because you can read as many books, because reading theory is one thing, but doing the practicals is another thing. Go for mentorship. It's not easy, but the good thing is that you can make a very handsome fee. You can really make, because this is where the novelty comes in. This distinguishes you as a unique and extraordinary lawyer who's taking up cases which are not taken up by a lot of lawyers. And when I've spoken to my wonderful friends in New York, when I was at 26 Federal Plaza, my wonderful friend Ed Cuccio, whom I cannot thank enough, senior lawyer, and 3 or 4 very senior lawyers, they were impressed to look at the strategy. They said, how come they didn't put your client in removal proceedings? I said, because they cannot do that, because I filed it as a class action. They were like, wow. You should know how to put the blocks and fight it out properly. You should know what the law is, how the law means, and you should definitely have a class behind you. You should add, I don't know, 5 or 6 other clients who are in similar situations. I said, if needed, they'd be happy to be complainants. They said that, that this didn't even come up. So this is good. So planning and executing a case is very important. And also, folks, you can, even if you're practicing employment-based immigration. So, for example, you're working for a software consulting company and you're the senior most paralegal. Try My Legal Software. This is meant for employment-based immigration lawyers, deportation lawyers. This is just wonderful. Family-based immigration lawyers, it's fantastic. General practice, it's great. And I think, doesn't matter what you practice, just see the difference of what you're seeing in over here. When you use it, and just basically take your practice to the next level. That's more important for me.
Yes, sir. So every time we have a session, we think like, maybe this is it. But every time you come up with so much more knowledge for all of our viewers, and we've been getting such a good feedback about the sessions that we're taking. We're
I
receiving.
want to train brilliant lawyers. I want to train lawyers who want to fight. I want to train lawyers who want to start the practice. I want to train lawyers who say, goodbye, law firm, I'm starting my own practice. I found a mentor and I'm ready to work with you. I want to see people not getting scared and starting their own practices. Even if you start a divorce, we'll help you out. In legal research, we can help you out. You're a lawyer, I'm allowed to do your legal research for you. You start a bankruptcy practice, we are there for you. You start any practice, we are there. Because the biggest thing is that moral support. And, I know the problem because I'm a lawyer too. You call this ABC Bar Association, the mentor is not available. You call this one, this is not available. So you lose that case. But here, we make sure that at least you get started, start rocking. So that's how we do it here. And if you need a memo written, that is also available, but give us time. We'll write a memo, but that is paid, of course. But don't be scared and sometimes you get an RFE, you're scared. You don't know how to reply. We are here for you. We are here for you. Can be an employment-based RFE. You got a specialty occupation-based RFE and you're scared what to do. Now, immigration is suspecting whether this is the actual job offer. All right, H-1B, I'm going to talk to you about H-1B too, folks. I'll teach you high-level H-1B practice, complicated matters of what I've done in H-1Bs and how you argue before the AO. That's what I love. Just simple H-1Bs. I mean, give me anything that's too easy, but give me something that's more difficult. What do you want to talk about H-1Bs? We'll talk about H-1Bs for paralegals, and because, your office is also good for, corporate, corporations. I believe, all these IT companies and for other people can also explore it, especially firms that specialize in employment-based, practices, or even if they're corporations.
So let's talk about the next session that we're going to have because the session is going to end. So people should know what we're going to talk about.
All right. Very interesting session. Marriage fraud and reliefs available to people who have been charged with marriage fraud under 204C. Very good for advanced lawyers, advanced practice, marriage fraud, and reliefs available to people who have been who have been charged with marriage fraud by the USCIS.
I'm assuming it's going to be another great session. And I'm looking forward for all our attendees who are people who are watching us live or not live. So please be there next Thursday, 3 to 4 p.m. EST. And you can register it and you can get all the upcoming webinars and you can get all the information there. In case if you've missed our previous episodes, you can check out all of our social media channels or our YouTube channel, My Legal Software, and you can get all the information there. So this session was sponsored by My Legal Software, and My Legal Software is a legal case management software that is focused for the law firm so that they can handle their cases in a better organized way. We have calendars, we have document management, we have mail management, we have accounting features, and we also have free demos and free trials available for people. We also offer special pricing for the non-profits. We are open for people to join in. We also are looking for expanding our community where lawyers can help each other. We also provide legal mentorship as explained in the session already. So I will be waiting, all of us will be waiting for all of you guys in the next session. So I hope you learned something in the session, you put up the notes. And again, if you have any more questions, you can simply mail those questions to us on legalquestions@mylegalsoftware.com. And we'll get back to you, get in touch with you. And thank you so much, sir. Any last words, sir? We're going to end the session.
So firstly, don't forget to attend the next session. And the next session is 204C of the INA, marriage fraud and options available to people who have marriage fraud has the order in their case, which is sad. People who get those final decisions on marriage fraud, what you can do for them. And again, as I said, we are going to talk about all these complicated issues about immigration. And this is meant for lawyers who really want to hone their skills to the next level. How you use the federal practice in these cases, what you can do, and how you can somehow, these are big fights, but these are like, good cases wherein litigators love to do these things. That's what we're going to talk about. Anything that's difficult in immigration, I love talking about it. And because I'm also here to learn from these great lawyers who are watching me, because as I said, my knowledge is a drop in the ocean. I'm here to learn from you. And don't forget, if you want to speak and if you want to come in and talk on this panel, you'll have to get in touch with Pianjali. And if you're very good in your field, we'd love to have you as a speaker. The standards are very high. And we want to make sure that feel free to send your information. This will also highlight to you as a lawyer on the page of My Legal Software that you've been a speaker, and this is good for you growing your practice and your publicity. And there are some requirements, and I believe you can talk to Anjali. So next week, very important. And for people, paralegals, lawyers, you can just basically speak to Anjali if you want to get this free demo or whatever that is. You also have this 14-day free trial. So,
yes.
And it's a pleasure. So it's time for me to leave, Anjali, and you should continue for the next 2 minutes. So I can basically wrap it up, and I'll be with you next week. So continue before I leave. Thank you.
Thank you so much, sir. Thank you so much for joining us. Thank you, everyone who is watching us live. And people who are interested in the software, you can get a free demo. All you have to do is either you can go to the website and you can click on the scheduling a meeting link, or you can leave your information there and we can get back to you. Alternatively, like I said, you can email us your questions or your requirement for the demo or whatever. You can just mail it us on legalquestions@mylegalsoftware.com. Thank you everyone for joining this session. I hope you had a good, knowledgeful session, and we are waiting for you in the next session as well. Thank you so much, everyone. Have a great day.